Hi, everyone. I'm Paul Coble, Chair of Intellectual Property and Artificial Intelligence at Rose Law Group. I want to give you an update today on a recent ruling in one of the many copyright infringement lawsuits regarding generative AI tools that are currently circulating through federal courts. This case is Andersen versus Stability AI, comes out of the Northern District of California, and has to do with one of the most popular text-to-image generation tools out there, Stable Diffusion. The plaintiffs in this case are a class of copyright owners who all had registered copyright works that were incorporated into one of the Lion 5 billion image data sets that were used to train a variety of generative AI models. The defendants are Stability AI and some of the other companies that Stability AI worked with to train and deploy the Stable Diffusion model. These include companies like Midjourney and DeviantArt that have incorporated the Stable Diffusion model into their own generative AI platforms. A quick note on the procedural posture of this motion before we dive into the substance of it. This ruling comes on a motion to dismiss, which is early in the case. This is not a ruling on the merits. So this is not the judge deciding whether or not Stability AI and the other defendants have infringed the plaintiff's copyrights. Rather, a motion to dismiss is just designed to test the sufficiency of the claims to make sure and weed out that any claims that don't have clear factual support don't go anywhere and are dismissed early on in the case. One other component of a motion to dismiss is that the judge is required to take all of the facts in the complaint as true and draw all reasonable inferences in the plaintiff's favor. So all doubts have to basically be resolved in the plaintiff's favor at this early stage. So with that procedural background, let's dive into some of the bigger issues in this ruling. This is a fairly long 33-page opinion, so I'm not going to go through all of the issues discussed, but I wanted to surface a couple of the bigger ones. The first one is some of the defendants' issue on direct infringement. So some of the defendants have moved to dismiss a couple of the theories of direct infringement from the case. The plaintiffs have alleged three different theories of direct infringement. The first is that the defendants had to necessarily make copies of all of the works, all of the images in the data set as part of the training process. The judge already ruled on that count in response to Stability AI's motion to dismiss earlier, and found that that count could stay in the case and that there was sufficient factual basis for the plaintiffs to allege copyright infringement. The other two theories are a bit more novel and nuanced. The second is called the model theory, and that basically is that the Stable Diffusion model contains all of the images that it was trained on. The trained Stable Diffusion model contains those images, and distribution of that necessarily infringes upon the copyrights. What the judge said in regard to that is that in order to contain the original models, it's sufficient that it contains it in math. It can transform those images into mathematical representations that can be converted back into images. And so the fact that the model is mathematical in nature does not defeat the model theory. Rather, so long as they're contained in the model, that's sufficient to allege direct infringement. The third theory of direct infringement is that in distributing this model, the plaintiffs or the defendants are necessarily distributing copies because users can simply enter prompts to extract those images from the model. And the judge kind of wrapped these together and found that because the model was capable of producing substantially similar, at least the facts alleged in the complaint are that the Stable Diffusion model is capable of producing images that are substantially similar, and that's the test for copyright infringement, to the original works. And it is irrelevant whether the model is transforming them into mathematical representations or actually containing the images, that those factual allegations are sufficient for both the model theory and the distribution theory of direct infringement. And so it kept both of those theories of direct infringement alive. Importantly, all of the defendants have signaled that they intend to rely on a defense of fair use for all of these theories of copyright infringement. And the judge has not ruled on that defense at this juncture. So we're likely to see some more motions related to fair use as we get further down the case, likely closer to summary judgment. The second interesting takeaway from this opinion has to do with induced infringement. The plaintiffs, in addition to direct infringement, have alleged that the defendants induce infringement when they put these models out there that are capable of allowing users to recreate the original works or images that are substantially similar to the original works. Induced infringement differs from direct infringement in that the defendants don't actually have to make copies of the work in order to be liable for induced infringement. But there's a different quirk to induced infringement. Direct infringement has no intent element. You don't have to intend to infringe somebody else's copyright in order to be liable for copyright infringement. But induced copyright infringement is different. The plaintiff has to prove that the defendant intended that the third parties create these copies, these substantially infringing copies of the plaintiff's original copyright protected works. Now, in order to examine the intent element, the plaintiffs point to a couple of statements by the defendant's CEO, specifically that the stable diffusion model takes 5 billion images and compresses all of those images into 2.5 gigabytes of data that can be downloaded onto a computer. The CEO also commented that the model, once fully trained, allows users to recreate any of the images that it was trained on. And the plaintiffs point to that word recreate as critical to the intent element. And in this case, the judge, at least taking those factual assertions as true and drawing all reasonable inferences as he must, agreed and found that those elements or those factual claims were sufficient to allege that the defendants intended that the users recreate or create substantially similar images to the images that were trained on, the copyright protected images, and thus would violate the copyright owner's copyrights. And the third main component of this ruling that I think is interesting has not to do with copyright, but actually with trade dress. Several of the plaintiffs have alleged that specifically the Midjourney defendant infringes their inherently distinctive trade dress in their unique artistic styles. And this is interesting because artistic styles are traditionally not the domain of copyright, and they're not protectable by copyright law. In fact, the Copyright Office recently reiterated this in their report that they issued last month on digital replicas, that generally speaking, artistic impersonations are not copyright infringement. However, in this case, the plaintiffs allege that that Midjourney has induced Midjourney users into infringing these plaintiffs' distinctive styles, the trade dress in their distinctive artistic styles. And specifically, they point to a list that Midjourney maintains of these artistic styles, and in fact, encourages its user base to create new images in these styles. And so the court said that these factual allegations are sufficient, that the artistic styles are inherently distinctive, that they're protectable by trade dress, and that the factual allegations around Midjourney's artist styles list was sufficient to allege the required intent element of induced infringement of trade dress. So the trade dress elements, trade dress counts are going to stay in the case, and we're going to see a little bit more about how they're treated as the case progresses. Be sure to follow along with Rose Law Group and the Rose Law Reporter for more updates on artificial intelligence news and emerging legal tech news. Thanks for watching.